Mike Lee had spent years branding himself as the Senate's constitutional warrior and was ready to lecture the young representative about her legal inadequacies. But Jasmine Crockett's knowledge of constitutional law was far deeper and more comprehensive than Lee could have imagined. Her systematic citations from Supreme Court cases would reveal just how hollow Lee's constitutional expert image really was. The Russell Senate Office Building's Committee Room 325 was steeped in the kind of institutional gravitas that seemed to seep from the very walls. Oil paintings of former senators gazed down from gilded frames, while the afternoon sun filtered through tall windows, casting geometric patterns across the polished mahogany table where some of America's most consequential legal debates had unfolded over the decades. On this particular Thursday in November 2024, the Senate Judiciary Committee was convening for what had been scheduled as routine oversight hearings on federal court administration, but the electric tension in the room suggested that nothing about this day would be routine. At the center of the committee's curved dais sat Senator Mike Lee of Utah, his slim frame perfectly postured in the high-backed leather chair that had become his throne for constitutional discourse. At 53 years old, Lee had cultivated a reputation as the Republican Party's foremost constitutional scholar, a modern-day founding father who could cite the Federalist Papers from memory and who never missed an opportunity to lecture colleagues about the original intent of the framers. His law degree from Brigham Young University and his clerkship with Justice Samuel Alito had given him the credentials to speak authoritatively on constitutional matters, and his sharp intellect and photographic memory for legal precedent had made him a formidable presence in judicial confirmation hearings. Lee's political brand was built almost entirely on constitutional expertise. Unlike colleagues who focused on foreign policy, economics, or social issues, Lee had positioned himself as the Senate's resident constitutional conscience, the member who could be counted on to identify when proposed legislation exceeded federal authority or when judicial nominees lacked proper originalist credentials. Conservative legal organizations regularly sought his endorsement, and his speeches at Federalist Society events were attended like seminary lectures by young conservative lawyers eager to learn from a master. What made Lee particularly dangerous in committee hearings was his ability to use constitutional law as a weapon. He had perfected a technique of asking seemingly innocent questions about legal precedent that were actually designed to expose his opponent's ignorance of complex constitutional doctrine. Many Democratic nominees and witnesses had found themselves trapped by Lee's carefully constructed inquiries, forced to admit gaps in their knowledge or to take positions that could later be used against them. Today, Lee had identified what he believed would be an easy target for his constitutional expertise. Sitting in the witness section was Congresswoman Jasmine Crockett of Texas, who had been invited to testify about the House Judiciary Committee's perspective on federal court reform. Lee had done his homework on Crockett, Harvard Law School, civil rights attorney, 2 terms in Congress, but he had also noted what he saw as weaknesses in her background. Her practice had focused on employment discrimination and voting rights, areas that Lee considered politically motivated rather than intellectually rigorous. She had no experience in federal appellate practice, no background in constitutional scholarship, and no record of engagement with the kind of high-level legal theory that Lee considered essential to serious constitutional discourse. In Lee's calculation, Crockett represented everything wrong with modern legal education: too much focus on social justice, not enough grounding in constitutional text and original meaning. He saw her testimony as an opportunity to demonstrate the intellectual poverty of progressive legal thinking while establishing his own scholarly credentials before a national television audience. What Lee didn't know was that Jasmine Crockett had spent the previous month preparing for exactly this kind of confrontation. Her legal background was far more extensive than her public profile suggested, and her knowledge of constitutional law ran much deeper than her focus on civil rights might indicate. More importantly, she had studied Lee's questioning techniques, analyzed his constitutional arguments, and identified what she believed were fundamental flaws in his legal reasoning. The hearing's first 2 hours had proceeded predictably, with various witnesses testifying about court administration, case management, and judicial resources. Lee had asked his usual probing questions, demonstrating his mastery of procedural details and constitutional principles. Several witnesses had struggled with his inquiries, validating his reputation as the committee's most formidable questioner on legal matters. But the atmosphere shifted dramatically when Committee Chairman Dick Durbin called Congresswoman Crockett to the witness table. As she settled into the witness chair, Lee's posture straightened slightly, the subtle body language of a predator detecting prey. This was the moment he had been waiting for, an opportunity to demonstrate the intellectual superiority of conservative constitutional thinking over what he saw as the shallow activism of progressive legal theory. Crockett's opening statement was measured and professional, outlining the House Judiciary Committee's concerns about federal court capacity and the need for additional judicial resources. She spoke knowledgeably about case backlog statistics, sentencing disparities, and administrative challenges, all important issues, but not the kind of high-level constitutional discourse that would give Lee the opening he was seeking. When Chairman Durbin recognized Lee for his questioning period, the Utah senator leaned forward with the confident smile that had become his trademark in high-profile hearings. "Thank you, Mr. Chairman. Congresswoman Crockett, I appreciate your testimony today, and I'm particularly interested in your perspective on the constitutional foundations of federal court jurisdiction." It was a classic Lee opening, a question that appeared reasonable on the surface, but was actually designed to lead the witness into increasingly complex constitutional territory where most non-specialists would quickly find themselves out of their depth. Specifically, Lee continued, his voice taking on the professorial tone that he used when preparing to deliver a constitutional lecture. "I'm curious about your understanding of Article 3's relationship to congressional authority over federal court structure. Do you believe Congress has plenary power to reorganize federal courts, or are there constitutional constraints that limit our authority in this area?" The question was expertly crafted. It required knowledge of constitutional text, Supreme Court precedent, and the complex relationship between congressional power and judicial independence. Most witnesses would either admit ignorance or provide a vague answer that Lee could then dissect with surgical precision. But Crockett's response immediately signaled that this exchange would be different from Lee's usual constitutional tutorials. "Thank you for that excellent question, Senator Lee," she began, her voice carrying the confident precision that had made her legendary in Texas courtrooms. Article 3 establishes the constitutional framework for federal courts, but as you well know, the relationship between congressional authority and judicial structure has evolved significantly through Supreme Court jurisprudence. She paused, pulling out a leather-bound notebook that several observers noted was considerably thicker than the standard hearing materials most witnesses brought. The foundational case, of course, is Marbury versus Madison, but I think the more relevant precedent for our current discussion might be Ex parte McCardle from 1869, where the court established that while Congress cannot impair the essential functions of Article 3 courts, it does have broad authority to define and limit federal court jurisdiction. Lee's confident smile flickered slightly. McCardle was exactly the kind of obscure but relevant precedent that constitutional scholars use to demonstrate serious legal knowledge. The fact that Crockett had cited it immediately, without notes, suggested that her preparation had been far more extensive than he had anticipated. However, Crockett continued, "I think we need to be careful about overstating congressional authority in this area. The court's more recent decision in Northern Pipeline Construction Company versus Marathon Pipeline Company established important limitations on Congress's ability to vest Article 3 judicial power in non-Article 3 tribunals." Now Lee was paying full attention. Northern Pipeline was a complex, technical decision that dealt with the boundaries between federal district courts and bankruptcy courts. It wasn't the kind of case that someone with a superficial knowledge of constitutional law would cite, and Crockett had not only referenced it, but had done so in a way that demonstrated she understood its implications for the broader question of congressional authority over court structure. "So to answer your question directly," Crockett concluded, "I believe Congress has substantial but not unlimited authority to reorganize federal courts, subject to the constitutional requirement that the essential functions and independence of Article 3 courts be preserved." It was a sophisticated, nuanced answer that demonstrated both broad knowledge of constitutional principle and deep familiarity with specific precedent. More importantly for Lee's reputation, it was the kind of answer that a constitutional expert would give, which meant that his usual technique of exposing witness ignorance wasn't going to work. Lee tried to regain control of the exchange by diving deeper into constitutional doctrine. That's an interesting interpretation, Congresswoman, but I'm not sure it fully accounts for the original understanding of Article 3. When the framers established federal courts in the Constitution, they were creating a co-equal branch of government, not a subordinate administrative system that Congress could restructure at will. It was a classic move, pivoting to originalist interpretation and the founding fathers' intent, Lee's strongest area of expertise. He was essentially challenging Crockett to engage with the kind of high-level constitutional theory that he believed would expose the limitations of her legal background. But Crockett was ready for exactly this line of attack. You're absolutely right about the framers' intent to create judicial independence, Senator, she replied, her tone remaining conversational despite the increasing complexity of the discussion. But I think we need to be careful about how we interpret that original understanding. She opened her notebook and pulled out what appeared to be a detailed analysis of founding-era documents. For instance, if we look at Hamilton's discussion in Federalist 78, he specifically addresses the relationship between congressional power and judicial structure. Hamilton writes, and I'm quoting directly, "The legislature not only commands the purse but prescribes the rules by which the duties and rights of every citizen are to be regulated." Lee's expression had become noticeably more serious. Direct quotations from the Federalist Papers were his specialty, and the fact that Crockett was citing them accurately from memory suggested that her knowledge of founding-era constitutional theory was far more extensive than he had expected. But here's what I find particularly relevant to our current discussion, Crockett continued, flipping to another section of her notes. In the same essay, Hamilton acknowledges that while the judiciary must be independent in its decision-making, the structure and jurisdiction of courts necessarily depends on legislative authorization. He writes, "The judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated." The quotation was lengthy, precise, and directly relevant to the constitutional question under discussion. More damaging to Lee's position, it came from Hamilton, the founding father most associated with strong federal judicial power, and it seemed to support a more expansive view of congressional authority over court structure than Lee's originalist position would suggest. Lee attempted to counter with his own constitutional scholarship. "Congresswoman, I appreciate your familiarity with Hamilton's writings, but I think you're taking that passage somewhat out of context. The broader framework of Federalist 78 is actually about the importance of judicial independence and the danger of legislative encroachment on judicial authority." "You're absolutely correct about the broader framework," Crockett agreed, "which is why I think we need to look at how the Supreme Court has actually applied these principles in practice." She pulled out another document, this one appearing to be a comprehensive case law analysis. The court's decision in Sheldon v. Sill in 1850 is particularly instructive. Chief Justice Taney wrote for a unanimous court that Congress, having the power to establish the courts, must define their respective jurisdictions. Similarly, in Klein v. Burke Construction Company from 1922, the court held that the judicial power of the United States is dependent for its distribution and organization, and for the modes of its exercise, entirely upon the action of Congress, who possessed the sole power of creating the tribunals in which it is to be exercised. The systematic citation of Supreme Court precedent was devastating to Lee's position. He had based his constitutional argument on founding-era sources and originalist interpretation, but Crockett was demonstrating that the Supreme Court itself, including conservative justices like Taney, had consistently interpreted the Constitution as granting Congress broad authority over federal court structure. But Crockett wasn't finished with her legal demolition of Lee's position. "However, Senator, since you've raised the question of original understanding, I think it's worth noting that the founding generation's actual practice supports this interpretation of congressional authority," she continued, pulling out what appeared to be historical documents. The Judiciary Act of 1789, passed by many of the same individuals who had participated in the Constitutional Convention, gave Congress sweeping authority to organize federal courts, define their jurisdiction, and establish their procedures. More tellingly, when Congress passed the Judiciary Act of 1801 and then repealed it the following year with the Judiciary Act of 1802, essentially eliminating 16 federal judgeships that had been created just months earlier. None of the founding fathers who were still alive raised constitutional objections. The historical argument was perhaps even more damaging than the legal precedent. Lee had built his constitutional philosophy on the idea that original understanding should guide constitutional interpretation, but Crockett was showing that the founding generation's actual behavior contradicted his narrow reading of congressional authority. Lee made a desperate attempt to salvage his position by shifting to more recent conservative constitutional theory. Congresswoman, while historical practice is certainly relevant, I think we also need to consider how modern constitutional scholars have understood the separation of powers principles at stake here. It was a risky move, pivoting away from his strongest area, founding-era sources, toward contemporary constitutional scholarship, where Crockett might have even more expertise. But Lee was running out of options, and he hoped that his connections to conservative legal organizations would give him an advantage in discussing current constitutional debate. Crockett's response showed just how miscalculated Lee's strategy had been. "That's a great point about modern constitutional scholarship," she replied, her tone becoming noticeably sharper. "Are you referring to Professor Stephen Calabresi's work on separation of powers? Or perhaps Judge Frank Easterbrook's analysis of congressional authority over federal courts?" The specific references to leading conservative constitutional scholars caught Lee off guard. These weren't the kind of sources that a progressive civil rights attorney would typically cite, and the fact that Crockett was referencing them suggested that her knowledge of constitutional theory extended across ideological boundaries. "Because if we're looking at contemporary conservative scholarship," Crockett continued, "I think we need to acknowledge that even originalist scholars have generally accepted broad congressional authority over court structure." She pulled out another document, this one appearing to be a detailed academic analysis. Professor Calabresi's 2017 article in the Yale Law Journal specifically addresses this issue. He writes that the Constitution's text and the founding generation's practice clearly establish that Congress has plenary authority to create, eliminate, and reorganize federal courts, subject only to the requirement that Article 3 judges retain life tenure and salary protection. Similarly, Judge Easterbrook's opinion in re Chicago, Rock Island and Pacific Railroad Company states that Congress's power to establish the jurisdiction of federal courts is essentially unlimited, constrained only by other constitutional provisions. The citations of conservative legal authorities supporting her position was devastating to Lee's argument. He had expected to engage with a progressive legal activist who would rely on liberal constitutional theory, but instead he was facing someone who could cite conservative originalist scholars more effectively than he could. Lee's next question revealed his growing desperation. "Congresswoman, I appreciate your research into various scholarly opinions, but don't you think there's a difference between what legal academics write and what the Constitution actually requires?" It was a weak response, essentially dismissing constitutional scholarship altogether rather than engaging with the substance of Crockett's arguments. More problematically for Lee, it contradicted his own frequent reliance on academic sources and constitutional theory. Crockett recognized the opening and moved in for what political observers would later describe as the constitutional kill shot. "You're absolutely right that we should focus on what the Constitution actually requires," she said, her voice now carrying unmistakable authority. Which brings us to the Supreme Court's most recent and definitive statement on this issue. She pulled out a final document, and Lee visibly braced himself for whatever devastating precedent she was about to cite. In Department of Transportation versus Association of American Railroads from 2015, Justice Thomas wrote for the court, and this is a direct quote, "Congress possesses broad authority under Article 1 to establish the structure and jurisdiction of federal courts, limited only by the specific requirements of Article 3 regarding judicial tenure and compensation." Justice Scalia joined that opinion, as did Justice Alito, your former boss, I believe. The reference to Lee's clerkship with Alito was a subtle but devastating personal touch. She was essentially pointing out that even the conservative justices Lee most respected had rejected his narrow interpretation of congressional authority over federal courts. "But here's what I find most interesting about that decision," Crockett continued, her voice taking on the prosecutorial tone that had made her legendary in civil rights litigation. The court specifically rejected the kind of rigid separation of powers argument that you've been making today. Justice Thomas writes, while the Constitution establishes three separate branches of government, it does not require absolute separation. Rather, it creates a system of shared powers and overlapping responsibilities designed to prevent any single branch from accumulating excessive authority. The systematic demolition of Lee's constitutional position was complete. Crockett had not only demonstrated superior knowledge of constitutional law, but had done so using sources, conservative justices, originalist scholars, founding-era documents, that Lee considered his own intellectual territory. But Crockett had one final revelation that would cement Lee's intellectual humiliation. However, Senator Lee, since you've raised questions about constitutional interpretation and original understanding, I think it's worth addressing a fundamental error in your analysis of Article 3. Lee looked like he might be physically ill. The idea that he, a constitutional law expert who had built his career on constitutional scholarship, had made a fundamental error in constitutional interpretation was professionally devastating. You've argued today that Congress has only limited authority to reorganize federal courts because Article 3 creates judicial independence, Crockett continued. But that analysis confuses two different constitutional concepts: judicial independence in decision-making and congressional authority over court structure. Article 3 protects judicial independence through life tenure and salary guarantees, meaning judges can't be fired or have their pay reduced because of their decisions. But nothing in Article 3 limits Congress's authority to determine how many courts exist, what their jurisdiction includes, or how they're organized. The distinction is crucial because it goes to the heart of separation of powers. Judicial independence means judges must be free to decide cases without political interference. It doesn't mean that the judicial branch gets to determine its own structure and jurisdiction. That would actually violate separation of powers by allowing the judiciary to exercise legislative authority. The constitutional analysis was so precise and so damaging that several observers noted Lee physically slumping in his chair. Crockett had not only out-argued him on constitutional law, but had identified a fundamental conceptual error in his reasoning that called into question his entire reputation as a constitutional scholar. The silence that followed was unlike anything anyone in the committee room had ever experienced. Mike Lee, the Senate's self-proclaimed constitutional expert, had been systematically out-argued by a House member using his own preferred sources and methods of analysis. Lee made one final, desperate attempt to salvage his reputation. "Congresswoman, I think reasonable people can disagree about the scope of congressional authority in this area dash." "Actually, Senator," Crockett interrupted, her tone now carrying unmistakable finality, "I don't think reasonable people can disagree about what the Constitution says when the text, the original understanding, the historical practice, and 2 centuries of Supreme Court precedent all point in the same direction." She closed her notebook and looked directly at Lee with something approaching pity. Constitutional interpretation requires intellectual honesty and rigorous analysis of sources. When someone ignores clear precedent and mischaracterizes founding-era documents to support a predetermined political position, that's not constitutional scholarship. That's constitutional activism. The accusation of constitutional activism was particularly devastating because Lee had built his career on criticizing liberal judges for exactly that behavior. Having the charge turned back on him, with comprehensive legal documentation, effectively destroyed his credibility as a serious constitutional thinker. What happened next would be analyzed in law schools for years to come. Lee, faced with the complete demolition of his constitutional arguments and his reputation as a legal scholar, did something almost unprecedented in Senate hearing history. He conceded defeat. You've clearly done extensive research on this issue," he said quietly, his voice lacking any of its usual confidence. "I appreciate the thoroughness of your analysis." It wasn't quite an apology, but it was as close as a sitting senator would come to admitting that a House member had out-argued him on his signature issue. The political implications were staggering. Lee's entire brand was built on constitutional expertise, and that brand had just been systematically destroyed on national television. Chairman Durbin, recognizing the historical significance of what had just occurred, chose his words carefully. I think this exchange has demonstrated the importance of rigorous constitutional analysis in our work on judicial issues. The American people deserve representatives who engage seriously with constitutional text and precedent rather than using selective quotations to support predetermined political positions. The criticism of Lee's approach was unmistakable, and coming from the committee chairman, it carried institutional weight that would be difficult for Lee to overcome. In the days following what became known as the Lee meltdown, the political and legal communities struggled to process what they had witnessed. Video clips of the exchange went viral among constitutional law professors, with many noting that they had never seen such a comprehensive demolition of a politician's legal arguments in a congressional hearing. Conservative legal organizations, which had previously treated Lee as an intellectual leader, began quietly distancing themselves from his constitutional interpretations. The Federalist Society canceled a scheduled speech, citing scheduling conflicts. Law review editors stopped soliciting articles from him. And most damaging of all, other Republican senators began avoiding association with his constitutional positions. For Jasmine Crockett, the confrontation established her as one of the Democratic Party's most formidable legal minds and constitutional scholars. Law schools began inviting her to guest lecture. Constitutional law professors started citing her analysis in their scholarship. And Democratic leadership recognized that they had discovered someone who could match and exceed the Republican Party's best legal minds. The Constitutional Massacre, as legal blogs dubbed it, became required viewing in constitutional law courses across the country. It demonstrated how thorough preparation, intellectual rigor, and honest scholarship could triumph over reputation, political positioning, and superficial expertise. But perhaps the most important lesson was about the difference between genuine constitutional scholarship and constitutional performance. Lee had built his career on delivering constitutional soundbites and demonstrating superficial familiarity with founding-era sources. Crockett had demonstrated what real constitutional analysis looked like: comprehensive research, honest engagement with sources, and rigorous logical reasoning. The image that became iconic from that day was Lee's stunned expression when he realized the extent of Crockett's constitutional knowledge, contrasted with her calm professionalism as she systematically dismantled his legal arguments. It captured not just the end of one politician's intellectual pretensions, but the potential for a new era of serious constitutional discourse in American politics. An era where constitutional interpretation would be based on rigorous scholarship rather than political convenience, where legal arguments would be judged by their intellectual merit rather than their partisan utility, and where those who claimed constitutional expertise would be held to the highest standards of legal reasoning. The silence that had followed Lee's confident constitutional lecture became the sound of intellectual accountability reclaiming its place in American political discourse. And when that silence was broken, it was broken by the voice of genuine constitutional scholarship, rigorous legal analysis, and authentic intellectual integrity. Mike Lee's reputation as a constitutional expert never recovered from that November afternoon. Within 6 months, he had quietly stopped giving speeches on constitutional topics and began focusing on other legislative areas. His former role as the Republican Party's constitutional voice was never formally transferred to another senator. The party seemed to recognize that the intellectual standards for such a position had been permanently elevated. Years later, constitutional law professors would use the Lee-Crockett exchange as a case study in the difference between political performance and legal scholarship. Students would analyze how Crockett's systematic approach, using original sources, Supreme Court precedent, and rigorous logical analysis, had exposed the fundamental weaknesses in Lee's constitutional reasoning. But on that day, in that committee room, it was simply a Harvard Law graduate doing what constitutional lawyers do: reading the text carefully, researching the precedent thoroughly, and presenting arguments honestly. The fact that she did it with greater precision and deeper knowledge than the Senate's supposed constitutional expert made the moment not just a political victory, but an intellectual triumph that elevated the standard of constitutional discourse in American politics.